The electronic, broadcast, and print media have approached this court to grant them permission to record through audio, audiovisual, and photographic means the entire criminal proceedings in the matter of the state versus Oscar Pistorius. The matter brings into sharp focus the interface between the functioning of the criminal justice system on the one hand and the quest by the media to participate in that system on the other hand. This interface finds expression in a number of critical constitutional rights that are seemingly on a collision course with one another. These are the rights of an accused person and the prosecution to a fair trial on the one hand, and the freedom of expression rights of the media or the press, as well as the open justice principle. Pistorius is due to stand trial on a charge of murder arising from an incident that took place during the night of 14 February 2013, a date recognized by many as Valentine's Day. During this incident, Ms. Riva Steenkamp lost her life. Steenkamp and Pistorius were involved in a romantic relationship at that stage. This trial is due to commence on the 3rd of March in this court in just over a week's time. ETV and ESAT, who I refer to as the ETV applicants, approached this court in August last year by way of notice of motion, seeking permission to broadcast the entire criminal proceedings through audiovisual and or alternatively audio means. At that stage, the Director of Public Prosecutions attached to this court, as well as Pistorius, opposed the relief sought. Later, other applicants filed applications similar to the ETV application, specifically representing the print and broadcast media. The print media applicants sought the permission of this court to install cameras in the trial courtroom to take still photographs of the entire proceedings. Their application was similarly opposed by Pistorius. In the background, there were, however, discussions between all the applicants, the DPP, and to some extent, Pistorius, through his legal representatives, seeking to strike a compromise position regarding the relief sought by the applicants and the stance adopted by the DPP and Pistorius. At that stage, the broadcast media applicants had not filed papers, even though they were involved and represented in the discussions. These applicants filed their application on the eve of a meeting convened by the Deputy Judge President of this court, aimed at bringing all the parties together with a view to case managing and streamlining the matter. A decision that comes to mind is .com Trading, Pty Limited versus King and others. The issue in that matter was whether or not to allow the audio broadcasting of the King Commission that was investigating match fixing in the sport of cricket in South Africa. In a further matter, the South African Broadcasting Corporation Limited versus Thatcher and others, the court was directly confronted with a request to broadcast criminal court proceedings. The court there conducted an authoritative analysis of the legal landscape locally and internationally. And in granting limited coverage, that court stated that it had to exercise its discretion to issue a just and equitable order while taking cognizance of its inherent power to regulate its own proceedings. This involved balancing the right to privacy against the right of freedom of expression, which, in the case of the media, translate into freedom of the press. In addition to the .com and Thatcher decisions, the two courts in this country whose decisions bind me and this court have also spoken on this subject, and I have derived valuable guidance from the decisions concerned. One such decision is from the Supreme Court of Appeal in the South African Broadcasting Corporation Limited versus Downer SC&O and others. In that matter, the SCA considered and refused an application by the SABC to televise and sound record the appeal proceedings it was due to hear. This decision was taken on appeal to the Constitutional Court, whose judgment is reported as South African Broadcasting Corporation Limited versus the National Director of Public Prosecutions. In its majority judgment, our highest court, whilst confirming the Supreme Court of Appeal decision, explored the appropriate approaches to be followed by courts when considering applications of this nature. I will revert to these decisions later in my judgment. It must be stated that when considering the exercise of the media's freedom of expression right in the courtroom, one has to confront the elephant in the room, that is the right to a fair trial, which is invariably asserted against the former right. It is that situation that confronts us in this matter. Whilst these may not have been so pronounced in the .con matter, the clash of these rights has featured prominently in the decisions of the Supreme Court of Appeal and the Constitutional Court, and how the competing rights should be balanced. Pistorius contends that the live broadcasting through audio, audiovisual, and still photographic means of his criminal trial will infringe his right to a fair trial. His view is that the mere knowledge of audiovisual equipment, especially cameras, will inhibit him as an individual, as well as his witnesses when they give evidence. He has also asserted that his counsel may be inhibited in questioning witnesses and the presentation of his case. In his view, the requested broadcasting of his trial will have a direct bearing on the fairness of his trial. Pistorius contends that should the relief be granted, he will most certainly not enjoy a fair trial. His disposition is that the proposed media coverage will be inhibiting, and in view of the fact that witnesses will be subjected to searching questioning, the audio and visual recordings or still photography during the proceedings will be conspicuously intrusive and potentially distracting. He further asserts that the presence of audio-visual recording equipment and cameras in the courtroom could be conspicuously intrusive and regarded by his witnesses to be a potentially distracting feature. He further is of the view that covering his trial as is sought by the applicants will enable witnesses who are still to testify to fabricate and adapt their evidence based on their knowledge of what other witnesses have testified. Our Constitutional Court has been very vocal regarding the protection of the right to a fair trial. Indeed, any accused person who appears in a court of law facing any charge has the constitutionally guaranteed right to a fair trial, which includes the foundational values of dignity, freedom, and equality, which are central to a fair trial. In this regard, the Constitutional Court in State v. Zuguda and others, State v. Chilo, confirmed that the right to a fair trial is, and I quote, a comprehensive right and embraces a concept of substantive fairness, I close quote, and that at the heart of the right to a fair criminal trial and what infuses its purpose is for justice to be done and also to be seen to be done. There is, therefore, before me, a clear contestation of rights. In resolving that contestation, Section 173 of the Constitution enjoins me in whatever I do to ensure that the interests of justice are upheld. That section provides that, and I quote, the Constitutional Court, the Supreme Court of Appeal, and the High Court of South Africa each have the power to protect and regulate their process and to develop the common law taking into account the interest of justice, I close quotes. Our Constitution is underpinned by a number of values, and for purposes of this case, I refer to openness and accountability as found in Section 1D, which provides that the Republic of South Africa is one democratic state founded upon a number of values, including a multi-party system of democratic government to ensure accountability, responsiveness, and openness. In this regard, it is also important to take cognizance of the fact that Sections 34 and 35(3)(c) make it very clear that even criminal proceedings in this country are to be public. The basis for this is that courts of law exercise public power over citizens, and for this it is important that proceedings be open, as this encourages public understanding as well as accountability. I refer in this regard to what the Constitutional Court said in the matter of State versus Mamabulo. It is also worth our while to take cognizance of what the House of Lords has said in this regard in the matter of McCann-Teckington-Breen versus Times Newspapers Limited, to the effect that, I quote, "In a modern, developed society, it is only a small minority of citizens who can participate directly in the discussions and decisions which shape the public life of that society. The majority cannot participate in the public life of their society if they are not alerted to and informed about matters which call or may call for consideration in action. It is very largely through the media that they will be so alerted and informed. The proper functioning of a modern participatory democracy requires that the media be free, active, professional, and inquiring." I close quotes. Clearly, therefore, the freedom of expression right as well as the open justice principle come into sharp focus in the current application and require appropriate treatment and accommodation regarding the final relief to be granted. In balancing the competing rights at stake, it is my view that the objection by Pistorius to the audio-visual recording of him and some of his witnesses should not be taken lightly. It was argued on his behalf forthrightly that the inhibitory effect of audiovisual recording equipment, as well as the knowledge and awareness thereof by himself as an accused person and by his witnesses, will be great when they give their evidence. This potential was recognized by our highest court in the SABC versus NDPP matter. For this reason, I am of the view that the objection, insofar as it relates to audio-visual or televising and still photography of Pistorius and his witnesses when they testify, has the potential to deprive him of a fair trial on the grounds spelled out in argument on his behalf. I am persuaded that there is merit in his fears and that of his witnesses that they may be disabled somewhat in giving evidence. I treat this situation similarly to how I've discussed the audiovisual request. On the other hand, however, audio coverage, in my view, does not carry the inhibitory or intrusive potential as the audiovisual form of coverage. In my view, whilst there may be no visual image of Pistorius and his witnesses when they testify, they should, however, be heard on radio. I have further considered the extensive interest that the pending criminal trial has evoked in the local and international communities, as well as media circles. It is, in my view, in the public interest that, within allowable limits, the goings-on during the trial be covered as I have come to decide, to ensure that a greater number of persons in the community who are unable to attend these proceedings are able to follow wherever they may be. Moreover, in a country like ours, where democracy is still somewhat young, and the perceptions that continue to persist in the larger section of South African society, particularly those who are poor and who have found it difficult to access the justice system, that they should have a first-hand account of the proceedings involving a local and international icon. I have taken judicial notice of the fact that part of the perception that I alluded to is to the fact that the justice system is still perceived as treating the rich and famous with kid gloves, whilst being harsh on the poor and vulnerable. Enabling a larger South African society to follow firsthand the criminal proceedings which involve a celebrity, so to speak, will go a long way into dispelling these negative and unfounded perceptions about the justice system, and will inform and educate society regarding the conduct of criminal proceedings. I must hasten to mention that the decision I have come to should be embraced with the objective I have spelled out in this judgment. I mentioned in this regard that the reason that I mention this for the reason that it has come to my attention that there are media houses that intend to establish so-called 24-hour channels dedicated to the trial only, and that panels of legal experts and, in certain instances, retired judges may be assembled to discuss and analyze the proceedings as they unfold. Because of these intentions, it behoves me to reiterate that there is only one court that will have the duty to analyze and pass judgment in this matter, and it is this court. The so-called trial by media inclinations cannot be in the interest of justice as required in this matter and have the potential to seriously undermine the court proceedings that will soon start. Despite the order that I have arrived at, it must be understood that the presiding judge over the criminal trial retains the ultimate discretion during the trial regarding aspects of the relief granted in this matter, which may require her attention as the trial unfolds. I have also considered the compromise position that I mentioned earlier, reached by all the applicants with the Director of Public Prosecutions. In the circumstances, the following order is granted. The applicants under case number 10193 of 14, that is MultiChoice Pty Limited, Combined Artists Production, CC and Prime Media Broadcasting, a division of Prime Media Pty Limited, and I refer to them as the MultiChoice and Prime Media applicants, or their authorized representatives, are permitted to set up equipment in accordance with the specifications that I mentioned below to obtain a video and audio recording and or transmission of the permitted portions as indicated in this order of the criminal trial of Oscar Pistorius under case number 13/1/25513. 2. The technical equipment shall comply with the following specifications. 3 cameras, as depicted in Annex A, shall be installed in the courtroom where the trial is to take place at least 72 hours before the trial commences. The cameras shall be installed in locations in the courtroom which are as unobtrusive as possible, and so that the proceedings are not interfered with. The locations of the cameras shall be substantially in the areas of the courtroom indicated in Annex B. The cameras shall be remotely controlled from a control room, and no camera personnel are permitted to be present in the courtroom to operate these cameras during the trial. The cameras must be preset to ensure that no extreme close-ups of any witnesses, legal representatives, the presiding judge, or any person in attendance at the trial takes place. The equipment is not permitted to record in any manner any confidential communication between legal representatives or between clients and their legal representatives, or any bench discussions between the judge and any lay assessors that may be appointed. The presiding judge shall specifically direct when recording should start and when it should stop. The equipment shall be deactivated so that no recording whatsoever can take place while the court is not in session, including any breaks such as lunch and tea breaks, and during time before the court is in session and after the judge has adjourned the trial at the end of each day. The cameras shall not be accompanied by any movie lights, flash attachments, or artificial lighting devices, and no visible or audible light or signal is permitted. MultiChoice and Prime Media may install their own audio recording system, provided that this is unobtrusive and does not interfere with the proceedings. The judge president and or the deputy judge president and the trial judge and or the court manager may visit the control room to check how the recorded images would appear on the TV screens when broadcast, and to give directions regarding the images to be broadcast to avoid extreme close-ups. I now deal with the portions of the trial that may be recorded and broadcast. In the first place, MultiChoice and Prime Media are permitted to broadcast the audio recording of the entire trial in live transmissions, delayed broadcasts, and or extracts of the proceedings. MultiChoice and Prime Media are permitted to broadcast audiovisual images from the following portions of the trial only: in live transmissions, delayed broadcasts, and or extracts from the proceedings. 1, opening arguments on behalf of the state and on behalf of the accused, any interlocutory applications during the trial, the evidence of all experts called to give evidence for the state, excluding evidence of the accused and his witnesses. the evidence of any police officer or former police officer in relation to the crime scene, the evidence of all other witnesses for the state, unless such a witness does not consent to such recording and broadcasting, and the presiding judge rules that no such recording and broadcasting can take place. Closing argument of the state and of the accused, delivery of the judgment on the merits, and delivery of the judgment on sentence, if applicable. Any witness whose testimony is to be broadcast in audio-visual form may subject his or her consent to such broadcast to reasonable conditions, which shall be communicated to MultiChoice and Prime Media or their representatives by the state, including the broadcasting of the evidence from behind with the face of the witness obscured from public view, the broadcasting of the evidence from the front but with the face of the witness obscured from public view, the broadcasting of the evidence only by way of a wide shot, that is, the central camera placed at the back of the courtroom would depict the entire courtroom with the judge at the center of the image and the witness only visible in the background. Objections by witnesses to the audio-visual recording of their evidence shall be in writing and will be served on the Director of Public Prosecutions and the accused attorney and be delivered to the office of the Deputy Judge President at least 24 hours before the testimony of the said witness to avoid delaying the trial. The Judge President and or the Deputy Judge President shall first deal with the said objections in chambers, and if same cannot be resolved, the presiding judge shall make a final ruling on the issues after hearing the parties. The print media applicants or their authorized representatives are granted permission to set up equipment to obtain still photography of the criminal trial, subject to the following conditions. 2 still photography cameras will be fixed at locations within the courtroom. These will be used for purposes of taking and publishing still photographs of the court proceedings during the trial, subject to the following provisos. The cameras shall be installed in locations in the courtroom which are as unobtrusive as possible and so that the proceedings are not interfered with. Each of the cameras shall be controlled by one of the applicant's representatives who will at all times remain behind the cameras while court is in process. The aforesaid cameras may not be moved while the court is in session, and no changes of lenses or film shall be permitted while the court is in session. No extreme close-up photographs of any witness, legal representative, the presiding judge, or any person in attendance at the trial shall be taken. Flash photographs shall not be permitted. No artificial lighting devices and or visible or audible lights or signal shall be permitted. No cabling for the cameras on the floor of the court shall be permitted. No identifying names, marks, logos, symbols may be used in any equipment or clothing worn by the representatives of the applicants. The applicants are permitted to take still photographs during the entire course of the trial, excluding the accused and his witnesses only when they testify, provided that witnesses, other than expect witnesses for the state or police officers or former police officers who testify at the trial may object to being photographed while giving evidence, and if the presiding judge rules that such witness may not be photographed while giving evidence, the applicant shall refrain from doing so. Alternatively, may subject his or her consent to reasonable conditions, including that his face or her face be obscured in any photograph published or that only wide-angle photographs of him or her are allowed, meaning photographs that include not only the witness but as much the physical surrounds of the courtroom as is technically possible. Notwithstanding the above, and in the event that it becomes apparent that the still photography is impeding or will impede a particular witness' right to privacy, dignity, or the accused's right to a fair trial, the court may, after hearing all interested parties, direct the cessation of photography. The applicants are to make available at no cost and in clean form with no logos the still photographs referred to above to any media organization requesting same. The court may, on good cause shown, withdraw the leave or change the conditions I have mentioned. Furthermore, notwithstanding the above, The presiding judge shall retain a discretion to direct that in the event that it becomes apparent that the presence of the cameras or the recording and or transmitting and or broadcasting is impeding a particular witness's right to privacy, dignity, or the accused's right to a fair trial, MultiChoice and Prime Media and the print media will be directed to cease recording and or taking still photographs and or transmitting and or broadcasting the testimony. MultiChoice and print media are directed to make the feed from the authorized broadcast referred to above available free of charge to the applicants under case number 51545/13, that is the ETV applicants, and any other broadcaster in clean form that is free of any logos. There is no order as to costs. I hand down the judgment.
No more. eNCA.com